Hey, it's Chris Doherty coming to you with some legal questions today about real estate. We want to talk about text messaging and we want to review can we bind a seller through a text message or an email communication? That's the question today, okay? For real estate agents, what we know today is that the world is changing. There are more texts than ever before, okay? Real estate agents all day long are texting on their phones, they're emailing their clients, they're emailing other agents, and they are negotiating through text and email messages, often what they think is in a casual way. And there has been some court cases. Massachusetts Appeals Court had a case, St. John Holdings versus Two Electronics LLC, that addressed the issue regarding text messages. And in that case of St. John Holdings involved negotiation for the purchase of a commercial building. And the buyer broker had emailed the seller's broker an unsigned letter of an intent to purchase the building, and it was put in an attachment. That letter of intent, which was the party's intent to be a binding agreement, had to be signed by both parties. And then the seller's broker followed up by texting the buyer's broker. So, step one, the buyer's agent sends over a letter of intent unsigned to the seller's broker. Seller's broker comes back to the letter of intent and says this. The seller's name was Steve. Steve, who is the actual seller, wants the buyer to sign first with a check, and then he will sign. Normally, the seller signs last or second. I'm not trying to be stupid or contrary, but that's the way that it normally works. Okay, let me put the exact language up on the screen for you to look at here. Hold on, let me share my screen so you can see. Let me just pull up here. We're gonna go to Zoom. Let's go back to the meeting. Okay, got it. We're being live streamed. We know it. We're going to share the screen. All right, so let's go through the actual language. Steve, the seller, wants the buyer to sign first with a check, and then he will sign. Normally, the seller signs last or second. I'm not trying to be stupid or contrary, but that's the way it normally works. Can the buyer sign today and get it to me today? Okay, so that is the text that is sent. So in this case, the agent, the buyer, signed the letter of intent as was requested by the seller's agent, and they provided the check to the seller. However, the seller hadn't signed yet, and the seller didn't think that they had created a legally binding contract with the buyer yet because they hadn't signed. And then the seller got a better offer or a different offer, and they accepted the third party offer. And the seller refused to sign the letter of intent that they were instructed to give them a signed letter and deposit the check. The buyer thought that it had a contract and it filed suit. And there we had a lawsuit. And initially, the Massachusetts Appeals Court ruled that that text created a binding contract. Okay, that even though the seller hadn't signed initially, that text was sufficient because it had met the standards of a contract. Now, we all know in real estate, and for all of us agents out there, and if you are a buyer or a seller and you're hiring an agent, there's something called the statute of frauds. And the statute of frauds says that, hey, real estate deals cannot be oral communication. They have to be written communications. The statute of fraud requires that any and all land sale contracts involving real estate be in writing in order to be enforceable contracts. So you can't have any verbal real estate. In this case, the court reasoned that there was an offer that was provided in writing from the parties, that the broker in this case had accepted the offer in writing, that there was in fact consideration because they had dropped off that check. And the intention of both of these parties was to create a binding contract. Okay, so in St. John's Holdings, that court reasoned that the basic elements of contract formation were in fact met. And now, the court did revisit it later, and they got into this deeper issue about, did the broker have the seller's authority, and was the buyer in a position where it was reasonable that the broker had the authority? Okay, they kind of reversed the decision a little bit on this, but the message is for you, and the lesson is that we need to be very careful with what we are sending in writing, whether it's through text or email, because it is possible that a claim could be made that you have created a legally binding contract. Okay, and so what we advise our agents to do is make sure that in their emails they say explicitly in the bottom of the signature that this email cannot create a binding contract either through text or in email. Okay, and so you also want to preserve your text so that if you're ever in a situation that you can protect yourself, or if you want to make some claim, that you actually have the data so that you can go back to the court and show the evidence that you have. Okay, so I want to get into another issue here of what's happening in our market. There is something beyond the legal letter. And I don't want you to take my word for this. I want you to talk to your broker. You talk to your legal counsel. This is my legal disclaimer right here. Don't rely on me or my judgment. This is just going over a trend that's happening in the system, but it's going to change on a case-by-case basis, and you need your own legal counsel to be looking at this. But there is something that's called proper etiquette. Okay, and you all know what I'm talking about, and that is the real estate agent that gives you their word. And so you come up with an offer and you give that offer to an agent. Some agents will write back, we have a deal, or they'll tell you verbally, we have a deal. Now, if they told you that verbally, it's very unlikely under current case law that you are going to have any type of contract. That is the reality. But there is professional etiquette. If you are an agent on the other side, you should never say we have a deal unless you have express authority from your client. And then the second is, words do matter. That at the end of the day, your reputation will be sullied if you're the type of agent that goes around saying we have a deal, and then buyers go to their clients and get their clients excited, and then at the end of the day the agent says, sorry, we just accepted a third party. So we're dealing with two different issues. In the first case, you can potentially legally bind your client in text and emails that you believe are casual. Second, you likely do not have a claim that an offer is accepted if it's only verbal. But for the agent out there telling people that they have a deal and then saying, sorry, we accepted somebody else, there's a reputation aspect of this. There's a realtor component aspect of this, that the rules and regulations in terms of how you're supposed to conduct yourself in verbal communication as well as written communication. And so you want to be careful that you don't hurt your reputation because you're out there saying to people, we have a deal, and then 20 minutes later you're accepting another offer. It doesn't do well for the industry because the consumer hears this and they believe that the word should matter. So I think as an industry, we should raise our expectations, raise our standards, and be very careful, not just what we write in email and text, but what we say. Okay, and so if you're a consumer out there, you need to know that these things can and do happen. You could see in the St. John Holdings case, this turned into a lawsuit, and there was case law in our own Commonwealth of Massachusetts. And you need to be careful what you say as well, because even though the case law may not fully support it, somebody may be able to make a claim. I hope this helps. This is the lesson today. And the real estate market is moving along nicely. We're having a great year at our company. We're proud of all you, our agents, and proud of the industry and what people are doing every day. I hope that things remain as great and as strong in the country and in Massachusetts and New Hampshire as they have. And I look forward to seeing you all in the days